All right, we'll go ahead and get started. I'm going to start with just a couple of quick announcements. My name's Todd Hefner. I'm the treasurer of the Georgia Bar Construction Section, and also a member of the Atlanta Bar Construction Section leadership. This is our first Construction Law 101 program that we're doing. This will, if you're somehow not aware, this is going to be the first of a hopefully 15-part series that we kick off. You should be getting a lot of different emails from us about this. We've got three more CLEs coming up later this month as part of this series. On October 10th, we'll have Introduction to Design Professionals and Design Contracts. On October 15th, we're going to have Insurance and Bond Basics for Construction Lawyers. And October 27th, we're going to have Anatomy of a Construction Project and Key Players. Just tentatively speaking, the goal is to get all, say, 15 of these complete by probably April of next year. All of these are going to be recorded and made available for on-demand watching after the fact. So if you have any colleagues who wanted to get the content but were unable to attend, give it about 2 to 3 weeks after the live CLE, and we should have a recording up on the page, and we'll reference that in our future emails. And like I said, just be on the lookout for more emails from us advertising all the great programs we have in store. So with that housekeeping out of the way, I want to turn it over to Greg Droy. Greg Droy is a partner at Smith Curry Olds and is someone that if you've ever learned anything about Georgia lien law, really needs no introduction. I think of Greg as synonymous with Georgia and liens. So you're all in very capable hands for this presentation. So Greg, thanks again for taking part.
I appreciate that very much, Todd, and I appreciate your comments. We're going to talk today very quickly, because we only have about an hour, about Georgia construction liens and what they involve and what the impact of them is. We're going to talk first about who has lien rights, what the lien rights are, then how what you have to do at the front end of a project if you have to file a lien in order to preserve your lien rights if a notice of commencement is recorded, and that's an if. But if a notice of commencement is recorded, then as a second tier or lower subcontractor, you have to file a notice to the contractor and to the owner on a private project that you're there. Then we'll talk about what you have to do to file a lien. We'll talk briefly about the process for going after a lien, perfecting the lien claim, and then finally the defenses to a lien. And primarily the defense we're going to talk about is lien waivers. The biggest issues are going to be the upfront notice requirements and the lien waivers. That's where I get most questions when I give this program. So I'm happy to try to deal with any questions you all may have, but I appreciate if you can kind of, if you've got a question, you can ask it, but if you can save it till the end of the program, that would be good. And then I'll try to focus on those topics, but I'll try to target anything that anybody wants to talk about. Now, what is a mechanics lien is probably the first question you have to answer when you're dealing with mechanics liens. And a lien is an encumbrance or a lien, it's something that is filed on the title of the property, usually, that encumbers the property, and it becomes a lien against that property. Where it stands in the perfection of the lien claims may depend on the precise place where you are in that process or where your client is in that process. But generally, if you are working under the same contract on a project, everybody under that contract will have lien rights, whether they file within 90 days after they finish their work, and they finish their work within the first month or two of doing the work on the project, or if they continue to work on the project and they wait until the end of the project to file a lien, they're going to have equal lien rights. So there's no rush to the courthouse to try to get a lien filed if you're working under the same contract. There's a difference if you're working under different contracts, then your lien time will run from whenever the first work starts under the prime contract with the owner that you're working with. So it's possible if you have different contracts that you're working under that the lien time can start at different times. But again, you won't be able to affect the lien as a contractor or subcontractor or supplier. Your lien rights will be equal with regard to all of the other contractors, subcontractors, and suppliers working on the one project. If there are different contracts and different projects, then the time of the encumbrance will date from when the primary contract, when the work started under that particular contract. Now, liens serve two purposes. They are, first of all, to try to protect your lien, protect your rights in the property. And a lot of times it sounds like that's that's a protection that you may not need. But I can tell you, particularly in times of economic trouble, like in the 2008, 2009 time period, or in other times that we've had, there are times when a lien may be the only avenue that you have. I have had, over a 40-year career, I've had a number of different projects where the lien became the only way that we had to recover against a piece of property. I had a case in Chicago that's the best example I can give, where we represented a sub, the steel erector, that had about $1.5 million worth of claims on a project. They got it. We had to go first on a lien against the subcontractor that we had a claim against. We got a judgment against them, and the subcontractor quickly went into bankruptcy. We then went after the lien claim, and in the meantime, the owner on the project went into bankruptcy. Everybody on the project that was directly involved with the construction of the project went into bankruptcy on that project, and there were 5 or 6 different parties involved. And if it hadn't been for the lien claim, we never would have recovered any money. We ultimately recovered our money by virtue of the lien claim that we had to protect, and that was involving a Illinois lien, so it had different processes, but the basic process was the same, trying to collect the money that we were owed. Now, a second purpose that a lien can serve is it may be a way to one, rattle the cage of the owner, tell them that you're out there, you haven't gotten paid, and that you are looking to get paid, particularly if you're a subcontractor or a subcontractor or a supplier on the project, not in direct privity with the owner. And if that's the case, then you may be having to give a notice to the contractor that you are anticipating getting paid, and you are looking to the contractor or looking to the owner to pay you. The owner unquestionably, this will always happen, but it may depend on the situation between the owner and the general contractor. The owner will turn to the general contractor and say, "This is a lien claim. I expect you to take care of the lien claim, Mr. General Contractor." And usually it puts some pressure on the general contractor to try to get the lien taken care of. So a lien serves two purposes, but ultimately it may, in fact, be the only avenue you have to getting paid on a project. Now in Georgia, who has lien rights? To put it very bluntly, basically everybody on a construction project in Georgia has lien rights, with the exception of a supplier to a supplier. So if somebody is providing lienable materials, labor, equipment, something under a contract, they probably have lien rights. Mechanics, contractors, subcontractors, the materialmen, the laborers, they all have lien rights to the project. The mechanics, if they're suppliers of material, may not have a lien right if they're only supplying to another supplier of materials, but otherwise they will have lien rights. Registered architects, foresters, surveyors, engineers, they have lien rights. Their lien rights can be a little different. Their time to initiate their lien and the priority that their lien will have will come by virtue of when they file their lien, as opposed to when work started on the contract that they're working on. But otherwise, they have lien rights as well. The machinists and manufacturers of machinery have lien rights. Contractors who build railroads, the lien law was written at the time that the railroads were becoming popular in the United States, and so they were specifically incorporated into the lien statute. And then suppliers who provide rental tools, appliances, machinery, etc., will have lien rights as long as they are not supplying to another pure supplier of rental equipment. So anybody except a supplier to a supplier of rental equipment will have lien rights. So generally, anybody and this can go down several more chains in this graphic here. Anybody who is supplying labor or materials to a first tier subcontractor, second tier subcontractor, third tier, whatever level, and is supplying it to that contractor, as long as they're not providing it to a supplier of materials only, they will have lien rights. The difference between a supplier to another pure supplier of materials will depend on whether a supplier to another supplier is deemed not to have lien rights in Georgia because they are not considered a party that has provided labor or some materials to the project itself. So if you are, one thing you want to look for as an owner or as a general contractor in defending against a lien claim is whether the contractor has a claim from a supplier to a pure supplier of materials. They will not have lien rights. The supplier of materials who ultimately provides to a subcontractor will have lien rights, but a pure supplier of materials to another pure supplier of materials will not have lien rights in Georgia. There was a question about whether or not that distinction applied in the 1990s when the lien law was viewed more broadly than the lien statute was written. But I can tell you in the last 8-9 years, the Court of Appeals has made very clear that a pure supplier to a supplier does not have lien rights. So that's the only entity that does not have lien rights on a project. And that's illustrated by this graphic. A general contractor, a supplier to the materialman who is in contract with another supplier of labor will have lien rights, but a pure supplier to a supplier does not have lien rights. Now, another clause that applies is if there is an anti-assignment clause in a contract. And an anti-assignment clause is a clause such as this clause in the A401 document, and this is the 97 version, that contains a slight difference, but we'll go over that in just a second. And this clause says that the subcontractor shall not assign the work of this subcontract without the written consent of the contractor, nor subcontract the whole of the subcontract without the written consent of the contractor, nor further subcontract portions of this subcontract without written notification to the contractor when such notification is requested by the contractor. Now, if you took that clause and you put a period in front of when such notification is requested by the contractor and deleted those words from that clause, then the suppliers or subcontractors below the level would have to get notice from the owner that they were being approved by the owner. And if they are not approved by the owner, then they will be without lien rights. And that's not a very well-known basis for defeating a lien claim, but I have used it in several cases where the contract or subcontract said that the contractor or the owner had a right to approve of the contract or the subcontract, and they did not specifically approve of it, and the contractor was without lien rights. And it sounds pretty unabashed and very difficult, and it can be. It can be a tough thing for a subcontractor to hear that it's gone through all the things that it had to do and that it does not have any lien rights any longer simply because the contract contained this kind of clause. What I recommend the subcontractors do is, one, obviously a contractor, I think, should provide a copy of the contract, its contract with the owner, to the subcontractors and suppliers on the project. They don't have to, but I think it makes it much more difficult for them to rely on it if the subcontractor has requested a copy of the prime contract from the general contractor. So I would generally request a copy of the prime contract from the general contractor. If they do not provide a copy, so you don't know whether or not there's this type of clause, what I would recommend that the subcontractor do is that he send a notice to owner, which we will talk about in the next section, to the owner and the general contractor on the project, which is required in many situations. But even if it's not specifically required, that they send a notice to contractor that they are going to be on the project, providing the information that's required in a notice to owner, and stating that any questions as to whether or not you're approved on the project, that you are presumed to be approved on the project unless you're told that that you are not being approved on the project. And if you're not being approved, you want to get that notice as quickly as possible. There's really not a clean way around it. It's not clear if that will work or not. Getting hopefully approval through the contractor by sending a notice to owner, a notice to the contractor, and them not replying. But that's the only other way I can think of that a subcontractor supplier will have to get approval from the owner of them on the particular project. Now, a lien will include, and this changed about 10 years ago. There was a change in the statute that said, and this was a result of a case, it was the Manhattan construction case, that's where the Court of Appeals ruled that general conditions were not lienable. And that stunned just about all the construction lawyers I can think of in Georgia, but a lawyer for the subcontractor or the general contractor came out and said, we don't see that the general condition costs went into the project. They didn't become part of the physical part of the project, and therefore were not lienable. That was changed. We changed that in 2012 or so, and that, I think it's 2013 actually, but we changed it to provide that anything under the contract with the general contractor was lienable unless it specifically was not, such as no damage for delay clause. If there's a no damage for delay clause, you will not be able to recover damages for the delay, but you can recover damages for your labor and materials and other things that you provided to the project. Generally, a lien will incorporate all the labor that's provided to a project, all the materials that are furnished and used and incorporated into the project, and we'll come back to that in a second. Materials that are consumed in the process, small materials, small tools, they're lienable. All the fixtures, anything that's a fixture, that becomes a lienable item. Again, presuming it's not being supplied by a supplier to a supplier, and all rental equipment being supplied by somebody who's providing labor, that all of those items will be deemed lienable on the project. Now, the one distinction I was mentioning with regard to materials is whether or not, let's say you've got a client who's a supplier of materials, and they supply the materials to the project, and they think I supplied $100,000 worth of equipment to the project. I think it went to the project. I'm going to file a lien, and I always would file a lien, whether you know that you've got time or you've got a lien right or not. But the thing that you have to prove is that the materials were actually used in the project. If it is assumed that if you supply materials to a particular project, that the materials were used on the project and are good against that project. However, it's a rebuttable presumption. So the owner or a general contractor can try to prove that they did not receive the materials, or they were not used in the project. They were sent to a different project and were not used in the project and are not lienable. So you have to be able to prove, one, that you shipped them to the project, and two, that they were used in the course of the project. If the owner or contractor can't prove that they weren't used and you can show that they were shipped to the project, then you've got a presumption that they were lienable. But if the owner or the contractor rebutting the lien can show that they were not used in that project, then you will lose the lien rights on that project. And that makes sense because you're not increasing the value of the particular project. Your materials went to a different project, and you'd have a lien on that particular project. Now, regarding the front end notice requirements, and this is one of the areas where I think amazingly it's underutilized still. I mean, this has been the law now for about 30 years in Georgia, but there's still a number of contractors who are not aware of the statute or just don't use it. I think this is one of the most critical requirements that an owner can use. If they don't use it, these requirements do not apply to the lien law. But if they do file a valid notice of commencement, then the subcontractors and suppliers below the first tier, because general contractors are considered to know their subcontractors, their first tier subcontractors. Anybody below the first tier will have to send a notice to the contractor indicating that they have that they're going to be providing materials for the project and providing the information that's required by the statute. And that information is specifically required by the statute. I say that's largely true. The notice of commencement requirements, and we'll touch on that first. A notice of commencement is what commences this process with becoming obligatory. A notice of commencement is to be filed by the general contractor or the owner on the project. If it is not filed, then the subcontractor, none of the subcontractors have to give a notice to contract that we're going to talk about next. But if a notice of commencement is properly filed, then the burden shifts to the subcontractor. And as I go through, you'll see this is shifting the burden to the subcontractors. Once they give that notice, the burden shifts back to the owners to get waivers while the project work is going on. That's where the lien waivers come in. And if the lien waivers are given in the time 90 days expires, then the liens are gone. So there's this back and forth in the lien statute between who has the obligation to give what notice. And this is the first obligation that the subcontractor has to give the notice that they're working on the project. So the notice of commencement is recorded usually by the general contractor, but could be recorded by the owner. And it has to include this information: the name, address, and the telephone number of the contractor. If it does not include the telephone number or the address of the general contractor, it's not a valid notice commencement. So it has to include the name, address, and telephone number of the general contractor. It needs to include the name and location of the project being constructed with a legal description of the project being improved. This is one where a lot of people have messed up, failed to include a notice, a legal description of the property, and the failure to include that legal description invalidates the notice of commencement. So I strongly encourage you to, if you're dealing with someone filing a notice of commencement and they want you to do it, or they want to know what they need to do to it, what they need to include in it, they need to include the legal description. You can generally get that from the title description in the property records, but I'll just warn you, at times, some property descriptions can be a real pain in the butt to get all the property descriptions and get them all located. I've had some property descriptions that have taken me weeks to get. I had one on the Atlanta Motor Speedway several years ago, and there were like 60 different property descriptions that had never been put together in one property. They were just all these property descriptions that had been sent to the same owner, but they were in different places and so forth. And we had to attach all of the property descriptions to our lien in that case. But you've got to have the property that you're working on in order to have the property notice of commencement be a proper notice of commencement. You need to include the name and address of the true owner of the property. So again, you need to look in the property records and try to determine who the true owner of the property is. Sometimes that's easy. Sometimes it can again be a pain to try to figure that out. What I would generally do to try to locate the property records is, or the property owner's name, is to look in the property description for the property where it's located. If it's a street address, that will help locate through the tax records. You can locate who the property owner is. And then you can look in the property records to try to find who the property owner is. And that is, if you haven't used the Georgia Property Records website, it's GSCCCA, 3 C's, GSCCCA.org. And you can go on and you can search by county and you can locate the owner of the property. Sometimes it takes a while to search that, so you need to give yourself time to do that. But generally, you can locate the property and who the owner is in the title records for the property. The property tax record should also have the correct property owner name as listed in the property records. Don't rely on the prime contract. It could have the wrong title name. It could say, ABC Construction or ABC Property Inc. and the owner's name is ABC International Property Limited or something like that. And it could be a different name than what the correct property owner's name is, and it could invalidate the notice of commencement for that reason. So as to giving a notice of commencement, you want to be sure that you've got the correct name and address of the property owner. And the correct address of the property owner will also probably be in the property records as opposed to the lien record, the title records where the property is located. You have to include the name and address of the person other than the owner at whose instance the improvements are being made. So if the owner is making is leasing the property to a tenant essentially, and they're going to have the property for 5 years or longer, and they make improvements in order to have a lien against the title interest of the lessee, you'll have to get the lessee's name and address as well. So you're going to have to go in and check the lessee's name. That should be in the lease, but again, you want to be sure by checking the title records or checking the online records at the Georgia Secretary of State. You can find out what the name of an owner or the lessee's name is from those records, hopefully. You need to include the name and address of the surety for any performance and payment bonds on the project. Who have you got as the surety for the project? And you need to have the name and address of any construction lenders for the project. If you've got a construction lender for the project, and unfortunately or fortunately, most projects have construction lenders, so you generally have to include that name. You need to include all of that information. If you do not include the address of the property owner or the name, the correct name of an owner, that can invalidate the notice to contractor, and then a notice to owner will not be required. The subcontractors and suppliers will not have to give notice of their presence on the project at the front end in this notice. Now, presuming you have given the proper notice, you also have to, or the statute says, and when we wrote it, we intended it to be, the notice to contractor had to be recorded within 15 days of when you started work on the project. Sounds good, still says that in the statute, and it's absolutely not required. It is, there was a member of the Court of Appeals who's no longer on the Court of Appeals, who I think hated liens and did his best to find ways around them. And he said that the 15 days was not a mandatory time period to have to file a notice of commencement. So I would file a notice of commencement at any time. And if your client is the owner or the general contractor and they forget to file a notice of commencement and come back 15 days after starting work on the project, I tell them, go ahead and file the notice of commencement. Anybody that's requested a copy of the notice of commencement, I'd send them a copy. You've got 10 days to send them a copy from when the notice is requested. And that's a question that's up for grabs in the Court of Appeals. But I would send them a copy of the notice of commencement, and I would send it to anybody else that requests a copy of the notice of commencement. And that's when a subcontractor is trying to give a notice to contractor, the requirement from subcontractors and suppliers, he should also request a copy of the notice of commencement. If he's not been able to find it himself, he should request a copy and allow himself more than, you got to give at least 10 days for them to respond to it. I would try to send a copy and ask for a copy of the notice of commencement as soon as possible so that you get one within the 30-day period that you have to request a copy of the notice of commencement, have to file the notice to owner. You do have to file that notice to owner within 30 days when there is a valid notice of commencement. Don't ask me why 30 days is mandatory and 15 days is not. I really can't tell you. This is just the way that this one judge, and there have been 3 cases that have held it, that the judge held that the 15 days is not mandatory, but the 30-day period for the notice to contractor is. Now, once you have given, once a notice of contractor is recorded, assuming it's a valid notice to contractor, then the subcontractors at the second tier or lower level have to send a notice to contractor. And the notice to contractor has to go to on private projects, has to go to the property owner and the general contractor, has to go to both entities on the project. So it's important that you make sure that you know the address of the owner and the general contractor. You can usually find that in the notice of commencement on the project. And you have to include in your notice to contractor the following information: the name, address, and telephone number of the person providing the labor, services, or materials. Who are you? Who are you representing? Who is the claimant going to be? that needs to be included, and their address and their telephone number. And you need to include the correct name as well. If you don't have the correct name, that could invalidate the notice to contractor. The name and address of each person at whose instance materials are being furnished. Who are you supplying your labor or materials to? Who is the direct purchaser of your labor or materials? If it's a subcontractor, which it normally would be on a notice to contractor, you'd have to include the name of that subcontractor and their address. The name of the project and location of the project set forth in the notice of commencement. So here you get a little bit of a pass. You can rely on what the notice of commencement says is the property description. So you can rely on the notice of commencement for this purpose only, for the purpose of the notice to contractor. You cannot rely on it for a lien, but you can rely on it for the notice of commencement. You then have to provide a description of the labor, services, and materials that are being provided. It can be something as simple as I'm providing water pipe for the project. I'm providing sewer pipe for the project. I'm providing pipe for the project. Something that generally tells what you're providing, and if it's known, the contract price, anticipated value, or the amount claimed to be due. I think that the requirement to include the notice of the contract price, et cetera, has been pretty much watered down by the courts. However, I will say that if you go in and you put in $1, I'm providing $1 worth of material to the project, and you've got a contract to supply $1 million, I think you've got too low an amount, and I think there is a valid defense that you have not provided a notice of the contract price. So I would put in what you believe the contract price is going to be, and I had a case where before the Court of Appeals had issued a certain decision, and it's in your materials, but if it issued this decision that held that the dollar amount is not required for the notice, but I would include as much as you think that you could require under your contract for the value of the labor materials that are being provided under your contract. The notice of commencement has to be filed in the property records in the county where the project is located, or counties where the project is located. The notice of contractor just has to be sent by, and you can pretty much count this as the way that you should send anything dealing with liens. It has to be sent by certified or registered mail or by overnight service. And generally it's sent certified mail. That's the cheapest way to the owner and the contractor. So it does not have to be filed, but a notice to contractor has to be sent to the contractor and the general contractor and the owner by overnight service or by certified mail or by registered mail in order to be valid. But the notice to contractor needs to be recorded in the property records. The notice to contractor statute also says, and we wrote this to be sure that it would say this, that a copy of the notice to contractor has to be recorded on, or has to be posted on the project location. However, the Court of Appeals has gutted that requirement as well as the 15-day requirement, said, nah, that's not a mandatory requirement. We're not going to make that an obligation that the owner or the general contractor has to post that on the project site. I'd still post it, but if you don't, it does not provide a defense if it is not posted on the project site. So the general contractor, or the subcontractors have to provide the information in the notice to contractor. The general contractor has to provide the information required by the notice itself, but does not have to meet the 15-day limit or the posting of the notice requirement. But if it posts a notice of commencement of the project, then a notice to contractor is to be provided by the subcontractors. Now, another somewhat little known, amazingly to me, requirement is a contractor's final affidavit. And there is, in Georgia, there is a little known requirement that the general contractor can require that that the general contractor, the owner can require that the general contractor provide to the owner an affidavit providing that all of its suppliers have been paid, or the general contractor can provide an affidavit that all contractors, all subcontractors and suppliers except A, B, and C, or whoever hasn't been paid has not been paid on the project. Amazingly, and this has been the law since I've been doing it 40 some years, I have only run into about a dozen cases where this has been an issue. If the contractor doesn't require the if the owner doesn't require the general contractor to provide it with a list of subcontractors who are not paid at the end of the job, then this requirement doesn't apply. So in most cases, the general contractor is not required to provide that. But I would encourage you, if you're representing the owner, to provide that the general contractor is to provide you with a list of the subcontractors remaining to be paid at the end of the project. And this is in exchange for final payment on the project. It doesn't apply to interim payments, but when final payment is being given out, and it's been given out by the general contractor can be required to provide the owner with a list of subcontractors who have not been paid, and anyone who is not on that list and has not filed a lien will lose their lien rights. I know that doesn't sound fair, but it's a way that is allowed for owners to cut off subcontractor pay rights for subcontractors who have not provided or not listed on the affidavit of the general contractor. And that statute, even if it's a false swearing, even if the contractor says, I've paid everybody on the project, and the contractor has paid nobody on the project, as long as the owner has paid the general contractor and the general contractor is not an entity that's within the control or of the owner, they're separate companies, then the owner can rely on that affidavit, even if it's a total lie. Not good for the general contractor. I think he can have a fraud claim brought against him, but the owner can be off the hook and you can lose your lien rights. So in order to protect somebody, there is an interim process that can be used. And I've seen this used about 15 to 20 times in the time I've been practicing law. And that's a contractor's a preliminary notice of lien rights. And if a contractor provides a preliminary notice of lien rights within 30 days of completing its work, and it has to be provided within 30 days, then its lien rights will be protected for the next 90 days, next 60 days. It has 90 days to file a lien. Its lien rights will be protected for the full 90-day period from any affidavit that's given, as long as it was not given before the contractor provided its affidavit of non-payment to the owner. And the contractor, the subcontractor supplier needs to provide in the preliminary notice of lien the name, address, telephone number. Again, you've got to include the telephone number of all of the potential lien claimant. You got to have the correct name, the name, address of the contractor, or the person at whose instance the labor, services, or materials were furnished. Again, you need the correct name, but you also have to have the address, the name of the owner of the real estate. You have to have the correct owner's name, a description of the affected real estate sufficient to identify the property. So you need to have a description of the affected real estate. It doesn't have to be dead on, but it has to be broad enough and that it doesn't have to be a legal description, but it has to be broad enough that it incorporates the property itself, and that somebody can find the property. One thing you can't use is you can't use the street address, which is, again, the Court of Appeals has ruled you cannot use the street address in your lien claim, but you can use your street address and provide a broader description that encompasses the property, describes the property, and that will be sufficient. And then you have to provide a general description of the labor and services and materials that were furnished or to be furnished by the claimant. So if you are a lien claimant looking to protect your interests, and you're not sure whether a notice may be given, or you are sure that a notice to contractor is going to be given, and you're concerned about it, you can send an affidavit is going to be given by the general contractor to the owner. You can provide a notice to the owner before that affidavit is given that preserves your lien rights for the time of the lien, the 90-day period that you have to file your lien. Okay. So if you've gotten all of those things out of the way, or you didn't have to give a notice to contractor because there was no notice of commencement filed, the one thing that is an absolute requirement is you have to meet the requirements of filing a lien and filing suit on your lien. These requirements are absolute in order to have a claim against the property. So the claim of lien, there are 7 elements that you have to include in your claim of lien. The claim of lien has to contain the correct name of the lienor and a description of its business, just generally. What, I am or ABC Mechanical Contractor Inc., and you have to use the correct name, the correct legal name of the lienor, and a general description of its business as a subcontractor, as a laborer, as a mechanic, whatever. That can be very general, but the name of the lien claimant needs to be in the lien claim. If you are using the correct name of the lien claimant and the correct name was not in the contract, then I would put in the correct legal name of the of the lien claimant, DBA, doing business as whatever. That way you've got both names covered if there's some question about which name is the correct name. If you've got the correct name in there and you've got it listed as that entity is filing the lien, then I think your lien is all right. The second item is the amount owed. The courts have held, and this is in the 90s again, but the courts have held that you do not have to include the amount that you were owed in your lien in order to have a valid lien. Now that's true if the lien, the party that you're liening is the party that contracted to have the work done. And more often than not, that is the case. There are situations where the property may have been transferred out, and that in those cases, then your lien may be invalid. But in most cases, the amount owed is not required. However, I strongly encourage you to include the amount owed. If it's too high, you can always the lien claim can be adjusted downwards. Putting in too much money is not improper. I don't suggest that you should include an amount that you believe is not proper. For example, don't include delay damages if the contract says there should be no damages for delay. But if you're not barred by some limitation and you've got a right to those contract damages, then I would include the amount that you're contending. That way it's easy for the contractor or the owner to see what your claim is for. You have to include the correct name of the owner. And here again, you've got to go into the property records and make sure you've got the correct owner of the property for the lien. If you get the wrong owner name, or you get the owner name from some document like the contract, and it turns out that owner's name is not correct, then you will not have a claim against the property. You have to have the correct name of the owner. If you're not sure, try to get somebody to do a title search as quickly as possible. The date the claim became due, that is generally required, but the Court of Appeals, just like an amount due, held that the failure to include the date the claim became due does not invalidate the lien. So you don't have to include the date that the claim became due. I encourage it. I think if it's wrong, it does not invalidate the lien, but I think it's important to try to include the date the claim became due. The one thing you want to be sure of is that you've got a date that is within the last 90 days. If the date that you put in your lien for when you last worked is the date that's more than 90 days before the date the lien is filed, your lien is invalid. So you want to have the correct date in your claim of lien, and you want that date to be within 90 days of filing your lien. And that's just one other thing to be wary of. Be careful in some counties like Fulton County, it can take several days to file your lien. And if you wait until day 88 and you file your lien, and then on day 91, you get a notice from the court, well, we didn't accept the lien because X, Y, or Z we don't deem is appropriate or was not valid, you can find yourself without a lien. So try to file your lien within, I would say within 75 days. And that way, if there's something wrong, the clerk's office should notify you, and you should have the opportunity to correct whatever that alleged invalidity was. So you've got some time to do that. Now, one thing is you've got, and I'll incorporate this here now, you have to mail a copy of the lien by registered or certified mail or overnight service, just like your notice to contractor. You have to mail that or send that to the owner of the property and to the general contractor if the general has provided a notice of commencement. I just send it to the owner and the general contractor. I don't worry with whether I have to send it to the general contractor. I just assume that I do, and I send it to both of them. It has to be sent within 2 business days of when the lien is filed, or else the lien is invalid. So you've got to file your lien within 90 days of when you last worked, and then you have to mail a copy within 2 days to the owner and to the general contractor. I strongly encourage you to do that. Otherwise, your lien will be invalid. It does not have to have anything special with it, but you have to keep track of. And I encourage you, if you go to the post office, keep a copy of the little white card that you get. Have them postmark it so that you can prove that it was mailed on that date. That the courts assume that that date is correct, and it normally is. I would just get that. It's easier than having to go in and testify yourself. Well, I took it down there and that's what it was, or I dropped it in the mail. I think you should have it postmarked in order to prove that it was sent out within 2 business days. Okay, you have to include a description of the real property and improvements with sufficient specificity so as to clearly identify the affected real property and or improvements. If you, again, you do not have to be specific as to where exactly the work was on the property. Let's say you got a 100-acre tract and you worked in 1 acre. In Georgia, you can identify the whole 100 acres. You get quite a bit of passing on this one in Georgia, as long as you've got the correct 100 acres or the correct 1 acre within the property description, you're okay. If that 1 acre happens to be outside the property description and you got another 100 acres, but you didn't get the 1 acre the work was done on, then the lien is invalid. So you've got to be sure that your lien incorporates the area in which the work was done, but as long as it's in that property, then that is sufficient. Be it 1 acre or 100 acres, as long as the work was done on the property described in the lien, then that is sufficient. And then you have to have 2 notices incorporated into the lien. I really don't think these are necessary, but they are required by the statutes. So you have to include these two notices. The first one has to include this language in this quotation. This claim of lien expires and is void 395 days from the date of filing the claim of lien if no notice of commencement of lien action is filed in that time period. That was added at the request of title examiners primarily, who wanted to be able to show that they had filed a suit or taken some sort of action on the lien, either a lawsuit, an arbitration demand, or filing a proof of claim in bankruptcy, in order to protect their rights. You have 365 days from when you file the lien to file your lien action. That has to be done within 365 days of when the lien is filed. If you don't do it within the time the lien is filed, within 365 days of the time the lien is filed, then it is an invalid lien. That's usually not as much of a problem, but there are some situations where somebody's messed up, waited too long, and filed their lien, and it's too late. Then you have 30 days in most cases to file a notice of the property records of commencing your lien lawsuit or the arbitration demand or the proof of claim in discovery, and if you, in bankruptcy, and you've got, that's 30 days on top of the 365-day requirement. So that's how you get to the 395 days. There is an excuse or a reason not to give the notice if a lien is bonded off and you do not have to file a lawsuit on the lien, but you can sue on the bond on the lien. Then you do not have to send a notice. I go ahead and send it anyway. But if you don't have to file it, then there's no requirement to file your notice of commencement. You just have to file your lawsuit within 365 days against the bond and whoever provided the bond and the principal on the bond, and then that's off the property records. And then the last thing is you have to include a notice stating that the owner has a right to contest the lien. And that's all it has to say, is that the owner has a right to contest this lien. We'll talk about that when we talk about notices that have to be sent by the lien claimant, and the notice of contest of lien, which shortens the time period. If the owner or the general contractor fights the lien, they can send a notice of contest, and then you have 60 days from that receipt of that notice of contest to take it out, to file a lawsuit, start an arbitration demand, file a proof of claim in bankruptcy. You've got 60 days to do that. And if you go beyond that 60-day period, you lose your lien rights. So that is the one thing that will change the 365 days from the date of filing the lien in order to preserve your rights. Now, quickly, in perfecting and foreclosing the lien claim, you have to be able to show in your lawsuit that you substantially complied with your contract or were unable to for reasons that were not your fault, or the fault of the general contractor or the owner, whoever above you. If it's the general contractor, that the owner prevented them from completing, that or a subcontractor or the general contractor prevented a subcontractor from completing its work. You have to show that you timely filed your claim of lien. You have to bring your action on the contract. You have to bring a lien action against the property owner to foreclose. And then you have to give notices of your lien action within 30 days of filing each of your lien actions. So you may end up having to file 2 separate lien actions. If you are in a contract where you are a subcontractor below the, well, if you're a subcontractor at any level, then you have, and you're not, the owner is not in the same county as the general contractor is, then you're going to have to file 2 separate lawsuits. You're going to have to sue the contractor first, get a judgment against the contractor or the party to whom you supplied your labor materials, and then sue on the lien claim in a separate lawsuit. If you can get them both in the same county, if they have an office in the county, if the owner has an office and the subcontractor has an office in the same county, or the general contractor, if you're suing the general contractor, has an office in the same county, then you can sue the owner and the general contractor in one lawsuit, or the subcontractor and the owner in one lawsuit. But if they do not have matching jurisdictions for their property location, then you're going to have to sue them in separate lawsuits. And you have to give the notice of filing your lawsuit to the in the property records of each lawsuit that you file. Unless the lien is bonded off, you have to file a notice of filing your lawsuit against the contractor or subcontractor you're dealing with, and then you've got to file your lawsuit against the owner. Now, lien defenses are any of the things that we've talked about. The things that are required is the lien claimant in the protected class. Yes, pretty much everybody except a supplier to another pure supplier is protected. Did the lien claimant sufficiently comply with the contract or purchase order? Did he substantially complete his work? Is the property or leasehold lienable? If it is, then he's got a lien right. Were payments properly applied? If they were, and that's going to be the owner's obligation to prove that, if they were properly applied, then that can be used to reduce the amount that's lienable. But if he can't prove that they were properly applied, they're not. The way to prove it is with lien waivers that we'll talk about in a minute. Was a notice to contractor given if it was required? Was the claim timely filed? Was the claim of lien properly mailed? Was a lawsuit timely filed? Was a notice of the lawsuit filed? Did the lienor obtain a judgment on the underlying debt and then go after the owner in a separate lawsuit if that was required, if they were not in the same jurisdiction? Is there a contractor's final affidavit? And if so, was it given before you filed your lien or your preliminary notice of lien rights? Are there lien waivers? We'll come back to that in a minute. And did the owner pay in full? And can he or she prove the payments were properly applied? The owner, if he can prove, and that's difficult to do, but if the owner can prove that the payments were made to the general contractor and the general contractor properly applied the payments, then he can use those payments to try to draw down the amount that is applicable, that the lien can be applicable to of the general contract. But I'll tell you that in most cases, it's difficult for the general contractor or the owner to get the documentation to prove that the payments were properly applied without lien waivers. And that's why these become important. By the way, page 43 and 45 of your materials, 43 and 44, include copies of the notice to contractor that I mentioned, and the preliminary notice of lien rights is described on page 45. And then on page 106 of your materials is the preliminary notice, or the interim waiver. What the interim waiver requires is that upon the receipt of the sum of whatever the amount is, the mechanic and or materialman waives and releases any and all liens or claims of liens that it has in the foregoing described property, or any rights against any labor and or material bond through the date of whatever the date is, and accepting those rights and liens that the mechanic and or materialman might have in retained amounts on account of the labor, materials, or both, furnished by the undersigned to or on account of said contractor for said building or premises. You can't tell a lawyer wrote that. Basically, the forms are, and these are straight out of the statute, these forms are required, the forms at page 106 and 107 are required for interim waivers that are provided during the course of the project. The final waiver is set out on page 108 and 109. And then a affidavit of non-payment is set out on page 10. And these forms went into effect essentially in 2021, that require, and they again became mandatory in change the wording from what had been used previously by virtue of the Manhattan case that I talked about before. And they say, no, I take that back. They weren't the Manhattan case. There were another case that was decided in about 2019 that said that if that general condition costs were not recoverable, and that if you claim for the for these other items, that you could not recover for general condition costs, and that this case changed the law to permit you to claim that you could recover for the value of that work, and did not affect your rights to other claims for breach of contract. You can, in other words, if you sign a waiver and do not withdraw it, then the waiver is valid only for the period and only for the lien rights, but it will not affect your breach of contract rights. And the case prior to that, it held that it was valid for your breach of contract rights. And so the interim waiver form includes this information. It does not have to be in all caps bold any longer, but it needs to be in at least 12 point. It could be in small letters, but 12-point type. And it has to include the notice on the second page, which is on page 107 of your materials. And it says that that notice essentially says that if you do not withdraw the waiver within 90 days, that was changed as well in 2021, that is not withdrawn within 90 days, then the lien rights and bond rights up to the date spelled out in the paragraph that I mentioned before, all of your lien rights up to that date will be waived, and all of your bond rights up to that date will be waived. In the form at page 108 to 109, it says that all of your rights are waived, because this is a final waiver, and this includes all payments on the project. So if you sign a waiver, and again, you have to include, doesn't have to be all caps bold, but if you include a 12-point waiver and sign this waiver and you do not withdraw it within 90 days, it becomes valid as to your lien and bond rights. You have waived your claims to those. You still have your breach of contract rights, but you have waived your lien and bond rights. So it's a loss of protection, but you do still have your breach of contract rights to the extent that the contracting party is still around and is still financially able to pay your claim. And finally, the form at page 110 of your and 111 of your materials says that if you that you can supply this affidavit within 90 days, and you file that in the property records, and if you submit the waiver, it withdraws your affidavit, your lien waivers that are have been provided to the owner or to the contractor within 90 days prior to the date that the affidavit of non-payment was provided, and it will withdraw any waivers up to that point. So when you give a waiver, be clear on what your 90-day period is for what waivers are still active during that time period, and withdraw every single waiver. If you don't withdraw that waiver within the 90-day period, then you will be considered to have waived your rights to that are applicable to that waiver. And then finally, the notice of contest of lien is it's page 112 of your materials. And this is what the notice that has to be filed in the property records within 7 days of mailing the notice, and has to be mailed to the address that's provided in the lien by the lien claimant. And it's giving notice that they have 60 days to file file a lawsuit or arbitration demand or proof of claim in bankruptcy, whichever is applicable, of their lien claim. And if they do not do that within, 60 days of when they receive the copy of the notice of contest of lien, if they do not withdraw their affidavit within that 60-day period, then their lien will be considered invalid. So if you receive an affidavit like that or a notice like that from the owner or the general contractor of a notice of contest of lien, you've got to be prepared to file a lawsuit or file your arbitration demand or a notice of filing your claim in bankruptcy. You've got to file that within 90 days of 60 days of the notice, or else your lien claim will no longer be valid. And with that, I have rushed through the last section, but I've gotten through the section, and hopefully you learned something today about liens and lien waivers that you may not have known before. And if anybody's got any questions, I'll be happy to hang on and take questions if you've got any.
Well, Craig, I just wanted to, on behalf of, I think at one point we were up to 106 participants, just want to say thank you again for taking the time to share some of your wisdom with us.
You're welcome. I don't know about wisdom, but I shared some words with you. So you got something from what the statute says.
All right. Well, thank you very much.
Thank you.
Ladies and gentlemen, this does conclude today's meeting. Thank you for joining and have a great afternoon.